The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the Appeals Court. I am Justice Rubin, and I am fortunate, and you are fortunate, because I'm joined today by two wonderful colleagues, Judges Henry and Walsh. We have one case on for today. It's number 2019-1792, Bank of New York Mellon versus HENRICKSON and another. We are in receipt this morning of a motion by the appellant, pro se appellants, to postpone oral argument. Given a series of prior postponements, that motion will be denied. We will, however, as an accommodation, permit the appellant to, subject to an order that we will issue after argument, to submit a written response to anything that occurs during argument today, within perhaps a week or so of today's date. So I just want to put that on the record and explain for the benefit of both the record and Attorney DeLinks what procedure we will follow. As I say, or as I imply, Ms. Henrickson, or Lutz Henrickson, is not present. However, we do have counsel for appellee, the Bank of New York Mellon, and we will hear argument from her. The rules of argument on Zoom are the same as they are in the courtroom, which is to say 15 minutes per side. And so with that, whenever you are ready, and the clock should appear in the Zoom's rectangle where the seal of the court is now. So with that, we will now hear from you, unless any other member of the court thinks I missed something. We will hear from you, Attorney DeLinks.
Thank you and good morning, Your Honors. May it please the court, my name is Marissa DeLinks. I am an attorney with Hinshaw & Culbertson. I'm here on behalf of the defendant appellee, the Bank of New York Mellon, as successor trustee. The issue before the court today is whether the order dismissing this appeal was proper, and our position is, of course, the order dismissing the appeal was proper because the appellants do not have a non-frivolous defense to this appeal. Essentially,
so counsel, I want to just slow you down a minute on these issues. So first, I assume they are. Can you confirm they are still in possession of the property?
They are in possession of the property. They still live at the property. Yes, I am not certain, however, Your Honor, whether my client still owns the property. I've tried to get this information, but sorry.
Because they may have sold the loan, or because someone purchased it at auction?
Because someone not purchased it at auction, it was later sold. After this,
wait, the property was sold, or the mortgage was sold?
Not the mortgage. The property was sold. The mortgage was foreclosed. I think, and I'm bringing this to the court's attention. I'm not sure. I'm trying to get information from the counsel that handled this eviction. But once the so you
don't know one way or the other.
I'm not certain, Your Honor. But they're still in possession of the property, even if my client doesn't own it. The person they sold it to allowed these folks to remain in possession.
But you don't represent them,
right? If you don't own the underlying property, how do you have standing to make this argument at this point? Wouldn't it be the now proper possessory owner to claim some action to remove these individuals from the property?
At a later hearing, if an eviction is necessary, then yes. But my understanding is the issue, as far as and perhaps it was foolish for me to bring that to the court's attention because I do not want to confuse the issues, but I'm not certain of that. And I would have to, I've reached out to the predecessor counsel, eviction counsel on the ground to find out this information. But what happens, as I understand it, is that in the housing court, after an appeal for the judgment for possession has been dismissed, an execution is allowed to be issued. Here, an execution was issued but never acted upon because the property later sold to a third party after the appeal was dismissed. And
someone bought a piece of property occupied by somebody that they'll have to at some point go through a whole new summary process action, or a successor in interest. Can they utilize your, I mean, they'll certainly have to do new execution and so on, right?
Well, it's a multi-family property, Your Honor. So this is a property that has tenants in it, as I understand. And so that is part of the confusion, that Ms. Lutz Henrickson was the borrower and the mortgagor on the property, and her husband, Mr. Henrickson, was a tenant at the property. That's how
unit?
this.
Wait, I'm sorry, in a separate unit?
No, same unit, but considered in terms of this summary process action, considered a different type of defendant.
He did not own any possessory interest. He was not on the mortgage or the title.
Correct.
Got it. Got it.
Okay.
Thank you.
Oh, wait.
So-
All right. So I have some, well, go ahead. I'll go.
I want to be clear what is on appeal, because that is not clear to me.
Okay.
So you seem to think one thing is on appeal, and it'd probably be best if we could use dates. So we have this November 26, 2019 order denying the defendant's motion to reconsider as to voidness and lack of subject matter and dismissal of the appeal. It seems like both of those are on appeal.
Well, to the extent, though, yes, those pertained after the appeal was dismissed. The appeal for the judgment in possession was dismissed. And then the Lutz Henrickson, excuse me, it's hard for me to say it.
Let's just say occupants
Filed this motion for reconsideration. And so it is on appeal to the extent it would have undermined the dismissal of the judgment for possession, which of course it didn't. So it's an open issue for the court, but it's open as it pertains to whether the order dismissing the appeal was proper and whether it showed they had a non-frivolous defense to this appeal.
Okay, and so that is what you're referring to when you say an appeal from the single justice to the full panel. Or no, that's something different. Do you think there's an appeal from the single justice to the full panel about the motion for an urgent stay pending appeal?
No, because that was never docketed, Your Honor.
Never docketed.
Right. And so, yes, it is confusing, and I understand these rules are very confusing, the housing court summary process.
I mean, does it matter they never paid the docket fee when we already know, and I think our court has accepted that they were indigent? You're saying it matters that they didn't check the right boxes and follow the right paperwork, right?
That's right. The appeal it's dead. It never was entered by the appeals court. So it's not that particular appeal in my view is not before this court.
Okay.
The notice of appeal has not yet been dismissed. Is that right? Or did we, in our usual course, we send out a letter when it's not docketed or something, and then it gets dismissed automatically or something?
I'm sorry to interrupt you, Your Honor.
No. Just, do you know if any of those steps have taken place?
It was my understanding that it was the order from the single justice when he transferred, when the appeal, because they filed the appeal in that court before the single justice, and it was transferred to this court. And in those papers, the occupants were advised that they needed to docket this appeal within a certain number of days, and then those steps never took place. And I don't know if I don't believe another order was ever issued after that fact from the appeals court, letting them know that they failed to take these steps, and therefore it was dismissed.
All right, so let me ask you this. I have more than one question, but I'm a little bit focused on this. You don't own the property piece of it. So it seems to me, if you in fact don't own the property anymore, your client doesn't own the property. Oh, and let me ask you actually first a factual question. You say it's a multi-family unit, multi-family building.
Right.
How many units are in that?
I'm not sure. I think 4.
And the entire building was owned by Ms. Lutz Henrickson.
Correct.
And she occupies only 1 unit, and there are income paying tenants in the other 3 units.
That's my understanding, yes, Your Honor.
Have they been paying her rent this whole time?
That was my understanding, Your Honor. But you'd have to ask Ms. Lutz Henrickson.
All right, so now let me ask you this. It seems to me that if you sold the property, obviously with some exceptions, so we don't have the facts before us, one of 2 things happens here. Either the case is moot, because as between you and Ms. Lutz Henrickson, there is no conflict. You aren't in a dispute. You don't own the property, you sold it. Or I suppose it could be a substitution of parties, but no motion to substitute has been filed, at least as yet. Now, I don't know what we do. I'll have to look into this. We all will procedurally. I have seen cases when someone dies and we get these suggestion of death notices. We stay the appeal to allow the personal representative to decide whether he or she wants to, pursue the litigation. But that's not, I've only ever seen that in a death case. So just to alert you, you may receive an order from the court based on the representations here to let us know something so we can figure out whether there's a case here or not.
I do appreciate that. Let me try to explain our position, or my position, as to whether or not, although I've been trying to find this information out from predecessor counsel, I don't have it, and why I believe the appeal can go forward the way it is. Because again, in my view, what is before the court at this point in time is the order dismissing their appeal based on the fact that they do not have a non-frivolous defense to this appeal.
I understand that, but why isn't that moot? You don't care anymore, right?
Well, we do, because we want clear title. We don't want this to, we've been.
You don't want anything. Your successor wants clear title.
But we've sold the property to successor counsel, successor to the successor owner based on clear title, because the foreclosure went forward, and then we had a judgment for possession.
Are you
and that is not an appeal.
Are you their title insurer?
No, sir. No, Your Honor.
You see what I mean? Like that seems like it's their problem and their title insurer.
I do agree. And then I could be completely mistaken. I know the property was being marketed for sale, but I don't.
Have you checked the registry to see if there is a deed?
I have not, Your Honor. I have not. I didn't even know that
we do that, right? That's a public.
How long would it take for you to nail this down one way or the other as to the ownership? 30 days, 60 days?
Oh gosh, no, it wouldn't take very long. I unfortunately, I don't have the I've never been told by my client, because it's a different, it happens in a different place, because this is an REO property. It's not owned by them anymore. Even, it's hard to explain. I can do it within 30 days, within 2 weeks.
What is an REO property? So
it's a real estate owned property. So what happens in the mortgage industry is, after a foreclosure takes place, but while the new owner of the property, the mortgagee, then these companies then transfer that to a different part of the company to deal with the marketing and sale of the properties.
Oh, I see.
And all of that stays in place until there is, say, a judgment for possession, and then they can move forward, because at that point they have the right to sell the property, or do whatever they want with the property, market the property for sale.
At this point in time, attorney, that I'm clear, there's no dispute that Bank of Mellon, or if that's the right, but that your client has no ownership interest in this subject property. I understand you want to make sure that whatever you did before has clean title, et cetera, but you stand before the court saying it's no longer ours.
I can't say that. I brought it to the court's attention because I am concerned that it may no longer be ours, and I don't know the answer. I knew the court wanted to ask questions. obviously, because you had the papers before you and then you ordered oral argument. And I wasn't sure what you were questioning. So that's why I was trying to find out what's going on here, looking behind the scenes to see how can I help the court understand and answer questions.
Right. No, and I
Right,
appreciate
so-
that, but my thought would be, and correct me if I'm wrong, if the occupants appeal an order related to this eviction, how is it that you're able to sell while there's a live issue before this court?
Because
Generally speaking, it stays. And I think what you're going to tell me is because it's not about the possession.
Right. Once the judgment for possession issues, you can actually, even if they appeal the dismissal of the appeal, right? An execution can issue on the judgment and the people can be evicted, and that would moot the appeal. In an instance like this, when you have a tenancy, the mortgagee will often try to find a buyer that will accept the property with the tenants in it, because, believe it or not, they're not looking to put these people out on the street. I know sometimes people have bad views of my clients and banks, but they really are trying to work with them. So, and unfortunately, when these folks are representing themselves, they don't understand
Am I not
Yeah.
correct that they haven't been paying the mortgage?
Oh no, they haven't been paying the mortgage. The mortgage was foreclosed.
Yeah, but
Right.
okay, I mean,
They're not paying the mortgage. They're not paying.
I don't know. I mean, it's not about putting people out on the street, but presumably at some point you want someone to pay the mortgage. Let me ask this.
Oh, yeah.
The second party, Lee Henrickson,
Mhm.
your position is Lee Henrickson is not an owner and never was an owner of this property?
That's my understanding, Your Honor.
How is he a party? I don't understand that.
Because it's a summary process action, and you have to.
It's just to evict him as a renter of one of the units.
Correct.
And now let me ask you this. In order for his appeal from that to have no chance of success, don't you have to show that he signed an agreement for judgment? And did he sign an agreement for judgment? And your time has expired, but we're gonna keep going because it's turned out to be a little more complicated than we thought.
Our position is he did not need to sign that agreement for judgment, because the judgment itself specifically says that it binds all parties once it's signed by the court. And that's what occurred. The problem.
But it's an agreement for judgment. How can it bind a party who didn't join the agreement? I don't understand.
It specifically states it does in the order, Your Honor.
But he wasn't there.
And his attorney was.
Okay, so that's the question. That attorney represented both him and the wife.
That's right, Your Honor.
But the
Ronald Whitney
signature on it is a signature. Whose signature is on it?
Gil
His
Lutz
attorney.
Henriksen, and the attorney's signature is both on the agreement.
As counsel for Lee?
Yes, Your Honor. He represented both.
Does it say on the actual agreement for judgment? Because I think it doesn't. I haven't looked at it since reading this case initially. But I thought, I'll tell you, I'll be explicit with you. The question is, do they have any colorable argument for appeal? That's not the exact question, right? I don't remember what the exact phrase is, but that's basically it, right?
Right.
Do they have? And it seems to me that someone who didn't sign an agreement for judgment, but on the basis of it, that agreement for judgment is being evicted, has at least a colorable argument. Now, maybe you're right that the lawyer, I don't know enough about this. You know what I mean? But, but that doesn't seem insubstantial to me. It might even be a winning argument. Right?
Well, I'll tell you what, it could be, except for the fact that when they violated the order and they failed to vacate the property, and Bank of New York Mellon moved for the execution, neither Mr. Lutz, Mr. Henrickson, or Gil objected to that motion, that the request for judgment and execution to issue. And their attorney, then a hearing was held, and the attorney didn't appear, and neither defendant appeared, and nobody objected to the entry of the judgment for possession. on their side. So I don't, the first
So
time
your point is just that this is whatever, it's waived, is your point, I think.
it's waived. Yes, and then the first time they challenged the fact that he didn't agree to sign it was in their reply brief to this court. That's the first time in all of the long pleadings that they have filed and requests for reconsideration, the first time they've raised the issue that they did not agree to sign this and she was coerced, whatever it is in their reply brief to this court, which I haven't had an opportunity, obviously, to address other than right now.
Yeah.
Yeah.
Okay, so where in the record is it established that that attorney also represented Henrickson?
It would be in the docket. Let me find it for you.
So it should be in the housing court docket, correct?
That's
Early
right.
on,
It's
right?
actually in my supplemental appendix at page 2, Your Honors. It says Henrickson, Lee, party attorney, Ronald Whitney, Gail Lutz, party attorney, Ronald Whitney.
And
Okay.
where is the agreement for judgment? What page do I find that on?
Let me find that for you, Your Honor. Sorry that I'm.
No, I should know where it is, but
Yeah.
looking through multi-volume appendices, it's a little tricky.
You shouldn't know where it is. I should know where it is, Your Honor.
But we should both know, really.
Let me find it. Hold on a second. Hold on.
It's-
And it is A4vc. So I have it in there.
Yeah, I have them. I mean, I have it all electronically. So.
Let me see if I can find it in mine.
Okay, A2-109 works for me. Hold on.
Okay. So that's not, I don't have that in front of me. I apologize.
That's okay.
When you see us looking to the side, it's because we're looking at the record that we typically have on another screen.
I see. Thank you. I'm sorry that my head's down.
We're not,
That's
we're
fine.
not ignoring you. We're
I'm
studying the
sorry
materials in
about
front of
that.
us.
Yeah, 109.
I thought I had it in my papers too.
So what should a housing court judge do when they're reviewing an agreement, as happened here, that seems to include a party that did not sign?
Well, Your Honor, I don't know what happened in this case because I don't have a
Here's
record of what
exactly
took place,
right.
whether there was a canvassing, I don't know. And I
Well,
think,
what's your best case that the lawyer can sign on his behalf?
well, the lawyer is the agent of the principal,
Well,
and
yeah, I'm now looking at it, right? So it says I'm at that page 109, which maybe you have before you as well. The
I do.
undersigned parties hereby agree to the following facts and entry as a resolution of their case. Once approved by judge, now I'm at the bottom in bold, this agreement becomes a court order and both parties, presumably undersigned parties, are legally required to follow it. Plaintiff signed and dated by plaintiff landlord. That's not even signed and dated, but let's assume that plaintiff's attorney can do that. Signed and dated by defendant tenant, and it's Gail, defendant's attorney singular, and it's the attorney. I just don't see how this could bind Lee Henrickson. I mean, I don't mean to be, and I understand maybe it's a waived argument, that I understand, but I don't see, I mean, that seems like a problem, doesn't it?
well, it doesn't to me.
If it had been raised, again.
If it had been raised, perhaps that is viable, but it wasn't raised, and I do think that the attorney can bind that Ronald Whitney can bind his client.
No, I don't know. Maybe he can, maybe he can't, but it doesn't
Right.
say did. It's got singular defendant apostrophe S, and I understand it's a pre-printed form or whatever, right? But I don't, you know what I mean? I don't think,
Well, I
if I
do.
handed that to a stranger and said, is a man named Lee Henrickson bound by this? And they look at it, they'd say, I don't know who that is.
But let me just interrupt for one more minute, just because in most summary process hearings, it only matters what the owner of the property. So as long as the tenants have noticed that this place is being foreclosed upon and whatever, they don't have standing to raise some issue about the irregularity of anything. It's the owner of the property or mortgage that has anything to do, because they're the ones with the possessory rights. The occupants, unfortunately, sometimes get the raw end of a deal, especially in a multi-unit property. You know, the owner didn't pay the rent. She pocketed it or he pocketed it. And sorry, everybody, you get noticed because it's not even necessary to name the occupants. It's just Lee Erickson and anybody else living at this place. We're giving you notice here. So Attorney DeLinks, correct me if I'm wrong. The only person that needed the signature for it to be a binding agreement before the court, and oftentimes judges go through a colloquy even with counsel, depending on the court and the judge. But the only person that really matters, again, is the owner.
Gail. Correct.
But you need a judgment for possession against a tenant. And if the basis of the judgment for possession is this signed agreement, rather than whatever, we're tearing the building down, or you know what I mean, whatever it is or we're converting it to condos, or, I don't know, there's different rules for different things. Presumably, you need a basis for your judgment of possession against the tenant as well, right?
Well, you certainly would, but I agree with Judge Walsh that, here you have Gail Lutz Henrickson, who was the former owner of the property and the mortgagor of the foreclosed property, and she signs the agreement. When the judgment for possession enters, it will say judgment for possession, in favor of, against all occupants, in addition to the main party. So, and that is a binding judgment for the tenants of a property.
But what's your best case, though, that if you know the name of an occupant, that you can have a summary process against them without them being a party to it?
Well, here he was named,
right.
and so, all of the tenants
named, and then he doesn't sign.
He doesn't sign, but his attorney signs again, and I know it's all.
All right, so we're relying on the attorney. That's fine. So, but when we also have on this agreement, when the housing court here has entered a judgment nunc pro tunc, do you agree that the time for the appeal runs from the date the judgment was entered and not the nunc pro tunc date, or what's your position on that?
Well, it's interesting because we tried to challenge that. The eviction, the attorney that was representing Bank of New York Mellon tried to challenge that. I think that's what you're referring to. And was unsuccessful. We did not challenge that on appeal.
What do you mean he tried to challenge that?
He moved for reconsideration. I believe what you're talking about is when the original order entered, the judge instead of failed to, I forgot, he entered the judgment and failed to provide the 10 days for the appeal period. The execution was issued on the same day as the judgment, which was incorrect. And then he went ahead and corrected that. And then the defendants filed their appeal late. In spite of the correction, they still filed it late. And the housing court accepted the late appeal because of his prior error with regard to the execution and the judgment issuing on the same date, giving them lenience, which he really didn't have. He did not have the right to do. And so the Bank of New York Mellon opposed that, asked for reconsideration of that order, and that was rejected. We did not appeal that. So that's not a live issue before the court, in my opinion, the timeliness of their first appeal of the judgment for possession.
Okay. Okay, assuming that we are reviewing a single justice order for a moment, what do you believe the standard of review is?
If you were reviewing the single justice order denying their motion for reconsideration on the bond order?
Well, I know you say they never paid the docket fee, but they did file an appeal from the single justice to a full panel urging a stay. And they also, on February 21, 2020, they filed an emergency stay of execution, which was denied by the single justice because the single justice said they failed to show like a likelihood of success on the merits. And then we issued a notice of assembly of record and directed the defendant to the requirements of Rule 10, and
Right.
you filed an opposition to that. So I don't know if that's in front of us or not. But if we are reviewing a single justice determination, I'm asking what you believe the standard of review is.
Well, it depends. I believe it depends, Your Honor, on what order you're reviewing the single justice order. So the single justice denied the motion to stay for failing to show entitlement. I presume that would be abuse of discretion standard, but I'm really, I don't believe that's you're reviewing the notice that I'm talking about where the appeals court said you need to docket this appeal pursuant to Rule 10. I didn't brief any of that because I don't believe it's live. I don't think they briefed any of it in their papers. And so, yeah, so again, I've beaten the dead horse, I'm sure. It's just the issue here is whether they have, yes, they're indigent, but do they have a non-frivolous defense? And our position is that they don't pursuant to that agreement, and then the waiver of that agreement, the waiver of their right to say the agreement was improper, the stipulated order was improper.
Okay,
I hope I've
so
answered questions. I know.
Obviously, you're not. So what you're going to do is either file a confirmation of ownership or not ownership. I mean, you don't have to tell us who owns the property, but you need to tell us whether this particular party it continues to be an owner.
Okay, I can do that.
And as I said at the outset, we will issue an order, presumably sometime today, certainly today or tomorrow, letting the appellants, allowing the appellants to file some kind of written response within a week or so if they so desire.
Okay. I find it, I will say just this, I find it curious that they haven't raised the issue if the property has been sold. So I may be wrong.
They might not even know, right? They're no longer a party to the sale.
They would be told by the new owner because now they're tenants of the property. And so I may have it all wrong, and I apologize for confusing the court.
No, I think for candor, we appreciate
we
very
need
much
to know it. It's
raising the issue.
quite relevant. Yeah.
All right.
All right.
Well, thank
So
you.
are there any more questions? We've taken a lot of your time, Attorney DeLinks. Thank you very much for
I appreciate the court's time. Thank you.
If there are no further questions, the case is submitted. And that concludes our sitting for today. And we now stand in recess. Thank you very much.
Thank you.